Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm coming to you from my Brooklyn office, and we're talking about some recent verdicts in 2023, and these verdicts actually came down just a few days ago in December, holiday verdicts. So here's the first case. This is a case that's not from New York, it's from a different state, and it involved a truck crash. It's an interesting case. What happened was a 29-year-old man was driving, and he was driving his pickup truck, and he was driving it from Texas to Indiana, and it broke down on the highway. And it broke down in a way that a part of the pickup truck was still protruding onto the lane of the highway. And the gentleman, the plaintiff, he didn't put out flares or triangles because his employer never trained him or provided this equipment. So he just didn't have it and he didn't know how to do it. And a few minutes after he broke down, his pickup truck broke down, there was another truck driver that was doing a typical overnight intrastate shift. And that truck driver actually did not see, but this plaintiff had his hazards on and he had his lights on. And so he had his hazard lights on, they were blinking. And despite that, this other truck driver, the defendant, it was a lady, she never saw the plaintiff and she hit him at full speed, hitting the brakes only after the actual impact. So this tractor trailer crashes into the pickup truck that the plaintiff is sitting in, and only after the actual impact does the tractor trailer driver hit the brakes. So at the scene, the plaintiff refused medical treatment. He said that he was all good, and the defendants had a body cam video footage showing the police officer interacting with the plaintiff. And the plaintiff was smoking, walking around, joking, saying all was fine. And so the officer blamed the entire wreck on the defendant. Or actually, I don't know if this is worded correctly because he says, for the fact that he was protruding on the active lane of traffic. So maybe actually he blamed the wreck on the plaintiff because the plaintiff was the one that was protruding in the active lane of traffic. So maybe the write-up that I have is a little bit, has a little error in it. But so what happened was the plaintiff was diagnosed with a mild traumatic brain injury and ended up having back surgery. Now the defendants, what they did was they hired 5 different experts. They hired 5 doctors as experts to contest the treatment. And these 5 doctors said that the medical care was not reasonable, it was not necessary, and it was not related to the crash. They also hired a trucking expert to talk about safety and truck driving. They hired a broker expert, I guess, to talk about the difference between the truck and the broker or shipper liability that came into play in this case. And they hired an accident reconstruction expert, and they hired an economist. So let's see, how many experts is that? That's 5 doctors, 6th is the trucking expert, 7th is this broker expert, 8th is the accident reconstructionist, and 9th is the economist. So this is the defendant, right? The trucking company hiring 9 different experts to defend this case. So you see how the insurance companies and the trucking, especially for trucks, serious truck accidents, they really hire the best experts. They put on like a full war to try not to pay fair value. So on the Monday before trial, the broker resolved the claims against them and it settled, and the settlement was for $11 million. So it was a large settlement. And the employer refused to contribute anything at all to the pot. So this made it very interesting since the case was worked up to be tried against the broker. And the trial, all the strategy, everything was against the broker. And if the defendants blamed the plaintiff, then the plaintiff in turn was prepared to argue that the employer should bear some responsibility for not training the plaintiff as to what to do in a breakdown. However, the reconstructionists that the plaintiffs used blamed the broker and the driver of the other truck. So now the broker's out of the case, right, for 11 million. And so they had a happy client, but the three lawyers, there were three lawyers working on this case. And I know actually one of the lawyers, I was in some groups with her where we practice our trial skills. She's a really great lawyer, really nice person. And so her and the other lawyer in the case, they kind of looked over at each other and they said, let's still go to trial against the employer. And so, you know, they basically said that sounds kind of crazy because the whole case is worked up against, you know, a different defendant. But they said, okay, let's do it. I'm in. So it was kind of like a last minute thing. And then they called in another lawyer and all three of them started working on this case. And they switched the entire trial strategy 180 degrees in 1 week. They redid everything. They redid the exhibits. They redid the jury charges. They redid the theme, the voir dire, the jury selection, the opening statement, everything, because everything was against the broker. And now it was going against a different defendant. So the defense filed motions to a delay, to continue, saying the whole case included claims against the transport company, and it changed the week before the trial. And this was denied. This was denied because the claims had always been properly pled and nothing really changed besides the plaintiff's strategy. It was the strategy that changed. But, you know, the plaintiffs were still at a pretty huge disadvantage. And that is because they lost their trucking expert on the first day of trial, and they never deposed the defendant in the case. And the expert the defense hired said that triangles and flares were required by the plaintiff. And that particular expert was withdrawn, and he was outside the subpoena power of the defendants. And so no one had ever mentioned this particular defendant. I believe it was known as Titan. No one ever mentioned them as culpable in any expert report. And in fact, plaintiffs' own experts only blamed the others. So how could they prove that this particular defendant was at fault, that they were negligent, and also that they were the proximate cause? Because you have to prove both. And that was the defense argument. Like, how could you prove it? So what they did was they basically had a corporate representative that was going to be the voice of the company under 30b-6 federal law, and there's also state corollaries to this. So they had the corporate representative of the defendant, and they had him on the stand, and they did such a good job cross-examining or examining this corporate representative that they made this corporate representative prove causation. And, you know, this is the only way they could have proven causation because they lost their trucking expert. And so this particular defendant actually admitted that they were the employer, even though one of their defenses was that he was an independent contractor who was, I believe. So he did a really good job with this. He proved liability with this particular defendant. And even though they had three different lawyers, it was one man and two ladies. And what they did was they broke things down. So one lawyer, the gentleman, he did the voir dire, the jury selection, the corporate representative examination, and he also called plaintiff's economist. And then another lawyer questioned the fiancé, the mom, the sister, the friend, and the cousin of the plaintiff. And then a final lawyer, a third lawyer, did the opening statement, the treating doctor, the life care planner, the brain imaging doctor, and then did the closings, the summations in the case. So the jury came back with a verdict, and the verdict was $16,865,725. So I think it was a really great result because remember, they got an $11 million settlement. And on top of that, they got a 16.8, almost a $17 million verdict. And they also said that the judge in the case was very fair and very hardworking. They were very happy with the judge. So that's the case. It was from Texas, actually. I believe near Dallas was the trial. And yeah, it sounds like they did a great job. And, you know, my video is based on a write-up because I'm a member of a few different listservs, like I mentioned before in other videos. And so some of these listservs, we have a lot of members, and they announce results of what happened, and they send these reports or write-ups, which is really, really helpful. But if I'm not giving like full information about everything, it's because some trials that I do videos about, I actually could watch the trial on something like CVN, the Courtroom View Network. But this particular case, I'm limited only to the, I'm only limited to the email, the actual write-up that one of the attorneys did. So it doesn't have all the information in it. But I hope this was helpful. Let us know what you think. Let us know what questions you have. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. Happy holidays, and we will talk to you soon. Bye-bye.